Oh. Why is it on me?
No, I don't. No, we're not. Well, the camera fell off the bench and now it's not working. So I'm trying to get Kevin. Yeah, so I'll call you back in a minute. Okay, bye.
It's down there though. Then go to your name. Your name. And then put media in front of you. There you go.
So now, okay, it's working on here, but it's not transmitting up here.
She doesn't have it on.
Oh, start video. Were you talking now?
Yep.
I restarted the camera. You know, it's not.
There.
There it goes. And I just gotta adjust it and take it.
Here, I'll sit up there. I'm taller.
Good, right?
Yeah, 'cause he's a little taller than I am.
I'm sitting here and I'm like, and as soon as I got the camera off the tape, it was.
That should be good.
Yeah.
Just don't move it.
Do you have the real time up for the bench?
Do we have what?
The real time. Can I give you the code?
Oh, yeah, hang on 1 second, let me grab up there. The real time for the court reporter.
Oh,
Yeah.
Sorry, I forgot about it.
That's okay, I forgot about it too. What is the session code?
U, D as in Victor, 4.
Okay.
F as in Frank, H, M as in mother.
Got it. All right, we should be good there.
Yep.
Okay.
All right.
Yeah.
Okay, that's the meeting.
Okay. Thank you.
Yep.
Yes. Okay, bye. All rise. Superior Court for the State of Washington is now in session. The Honorable Chris Lenny presiding.
Please be seated. Good afternoon, everyone. So we are here on a motion for contempt brought by the state in Department of Labor and Industries versus Farm Boy Drive-In et al. Who do we have appearing for the state today?
Your Honor, this is Michael Hall, Assistant Attorney General.
Good afternoon, Mr. Hall. And who do we have representing the defendant?
Good afternoon, Your Honor. Jason Selfie on behalf of Matt Fowler, Mary Fowler.
Thank you. Good afternoon. I see that we have a number of media members present on the call, or the Zoom call, I should say. I'm just going to ask, does anyone have any objection to either still image or video recording of these proceedings? Okay, silence means no. So I'm going to permit those matters. There's no need to specifically request that permission, as I know the media typically does. You have permission to do so. So I'll just, a couple preliminary matters before we begin. We are here in Thurston County Superior Court in open court. We have members of the public who are here to observe. The door is open, but I believe we're at capacity. And so anyone who has been seeking to come in to observe these proceedings, who have not been able to come in due to our capacity restraints, has been provided a link to the Zoom call so that they could observe and participate in this manner. Are there any things that we need to address as to preliminary matters before we turn to the hearing regarding the motion? Mr. Hall, anything from your side?
No, nothing from the department, Your Honor.
Thank you. Mr. Kelsey, anything from your side?
Yes, Your Honor. I would like to note that this matter was essentially given to my client with about a 4-hour window, allowing them to respond to the allegations of contempt. I think it's pretty substantial, given the fact that the department is asking for fines upwards of $24,000 that my clients be allowed to properly respond to this motion. Additionally, my office was served via email in regards to this. I've not signed an electronic transmission agreement with the state in this matter, and it was done essentially the day my office was closed. So I'm not sure if this is properly before the court. I would contest that it's not. We do have a hearing set for next Tuesday. I think that's probably the more proper time frame to have this hearing, but I'll defer to the court on what Your Honor would like to do.
Thank you. Based on my understanding of the record at this point, I believe that this should be fairly straightforward, both legally and factually. And thus, if as argument progresses, there are matters, counsel, that you believe that additional time would have allowed you to better respond to or address certain points, that is fine. And I would consider in that context determining whether or not continuing this hearing would be appropriate. Based on my review of the record at this point, however, that does not appear to be necessary or appropriate. But again, we'll cross that bridge when we get there. Are there any other preliminary things you'd like to address, counsel?
No, Your Honor.
Thank you. So, Mr. Hall, this is your motion, and I'll hear from you first.
Thank you, Your Honor. And I don't have a great deal to say. You issued a temporary restraining order 2 weeks ago today in this case, directing Farm Boy to comply with the Department of Labor and Industry's order of immediate restraint that itself prohibited Farm Boy from providing indoor dining services. Since the order of immediate restraint, since your restraining order was issued 2 weeks ago, Farm Boy has been open for indoor dining services, as far as we can tell, every single day, including today. Last week, when we had a hearing, I mentioned that they were in violation of your order, and you gave a lengthy description and warning to Farm Boy about the potential consequences of noncompliance. Immediately after that hearing, they went online and said, we continue to stay open, and we therefore filed the motion for contempt the next day. I guess the only other thing I'd mention is we did receive some declarations that were filed yesterday. Those are essentially a set of pleadings that indicate that Farm Boy intends to continue to stay open. We are in the middle of a pandemic here.
And Mr. Hall, I have a question or a clarification that I'd seek from you. Continuously, there is this reference to Farm Boy being open. Isn't it the state's position that being open isn't the problem? Farm Boy is permitted to be open, to employ individuals, to sell food, to have customers come in and take that food from them. The sole point of the restraining order here is where those customers may consume that food. Isn't that correct?
That's exactly right, Your Honor, and that's why I apologize if I didn't choose my words carefully. I've been trying to say open for indoor dining services. This is a takeout facility. They can do takeout. They can do drive-through. The only issue is people inside sitting at tables in violation of the governor's proclamations and in violation of the department's rule.
Thank you. Mr. Hall, you may continue.
No, that's all I have. I think that, the continuance that it sounds like is being requested will do nothing more than allow Farm Boy to continue to violate your order until next week. The issue is simple. You issued an order, they're violating it, and that means they're in contempt. You explained that to them, and now it's time to issue an order. Thank you.
Thank you. Mr. Kelsey, I'll hear from you at this time.
Thank you, Your Honor. And again, our position is that the controlling declaration, I believe, in this matter is that is of Lindsay Banks. She's the officer that essentially is employed by Department of Labor and Industries. She covers a vast majority of, Southwestern Washington in regards to, compliance and whatnot. In her declaration, it does not say that she has personally observed a single instance where an individual is dining inside of the restaurant. Her declaration makes it quite apparent that there's a DOSH inspector whom we do not have an affidavit sworn under penalty of perjury that may have.
Counsel, do you deny that your client is currently offering dine-in services?
Your Honor, I can't make a representation one way or another because
I'm asking you to make a representation one way or the other, counsel, because this is a factual matter. You have a duty to the court. You have presented no legal argument in advance of this hearing, and it is your obligation as an officer of the court pursuant to the rules of professional conduct. If you don't know the answer to that question, that's fine. But I'm asking you a factual question that is the linchpin of this hearing today and why we are here. So, counsel, is your client currently operating indoor dining services?
I do not know, Your Honor.
Okay, you may proceed.
I honestly do not know if they are offering that, and that's part of the whole problem with having this short set. Is I've not had a chance necessarily to discuss all.
You
of that
haven't
with
had a
my
chance
client.
to speak with your client as to whether or not they're currently operating and having customers eat inside their restaurant. Is that true, counsel?
Your Honor, that has not been part of my conversation with my clients at this point, no.
I find that difficult to believe, but you may continue.
Thank you, Your Honor. In any case, there is one reference in this controlling declaration of Lindsay Banks that says there is some sort of other inspector that drove by Farm Boy and may have observed dine-in service. We do not, again, have any declaration from this DOSH inspector, have no idea who this DOSH inspector is, and quite frankly, we would argue that this is hearsay. In regards to the Lindsay Banks declaration, the only thing she indicates is she's driven by Farm Boy, the parking lot has been full, which could mean a multitude of things, and that there are people inside. It does not say whether she's gone inside, observed people dining in. It does not indicate anything. It does not indicate whether people are taking this food or these items to go. It's my understanding Farm Boy offers a multitude of dining services, including a bakery, takeout pies, takeout food, etc., etc. To hold someone in contempt based on speculation, we believe is inappropriate and improper. We don't think that the declaration of Lindsay Banks goes far enough to hold my clients in contempt.
Is there anything else you'd like to add, counsel?
No, Your Honor.
Thank you. Mr. Hall, it's your motion. You get the last word.
Thank you, Your Honor. I would suggest that if you haven't already done so, you take a look at the declarations that were filed yesterday. They indicate unequivocally that Farm Boy is open now for indoor dining services. They submitted those pleadings. That's all I have. Thank you.
Thank you. The court's prepared to rule at this time. This comes before the court on the state's motion for contempt in this case. The court has previously issued a temporary restraining order requiring that the defendants comply with the notice of restraint issued by the Department of Labor and Industries against the conducting of indoor dining services. Again, as I said at the outset of my question to Mr. Hall, I want to make it very clear about what's before the court today and what's not before the court today. What's not before the court today is whether or not the legislature should pass laws that allow the executive branch to issue certain types of restraint. What's not before the court is whether or not that's constitutional, or whether the executive, in the executive's discretion, should comply with what they believe is appropriate and issue certain types of orders pursuant to those laws. What's also not before the court is whether or not the executive, in its prosecutorial discretion, should bring this action. What's before me here today is an order or a motion seeking an order of contempt. When an order of contempt is requested from the court has a very limited inquiry that it is to engage in. First, was a validly issued court order ordered? I have heard no argument in this case indicating that my prior order is not appropriately valid. Secondly, and this is where I believe Mr. Kelsky focused his argument, is whether or not there has been a violation of that court order. The defendants point to the fact that they believe that the declaration submitted by the state is inappropriate to establish that there is currently indoor dining occurring at the Farm Boy drive-in. I'm going to go back briefly before I get to my conclusion about whether or not that's currently occurring. Again, my order did not prohibit Farm Boy from being open. My order did not prohibit them from employing individuals to prepare food to sell to customers who desire to consume that food, nor did it prohibit anyone from being inside that dining establishment to acquire that food. The only thing that my order prohibited was for those things to occur, and then for an individual, a customer, to remain inside that building to consume that food. I find that the state has satisfied its burden to establish that that has occurred in this case by two different ways. First, I do believe the declaration of Lindsay Banks is appropriately sufficient for me to make that determination that there has been a willful violation of this court's order. Secondly, I also agree with Mr. Hall to the extent that there was any ambiguity. Mr. Kelsky, in supporting his position and filing those declarations, made it abundantly clear through declarations of people indicating that that's exactly what is currently occurring and has been occurring since this court has issued its order. And thus I find that there has been a willful violation of this court's order. This court, in these circumstances, it has been made very clear by the Supreme Court that the court must enforce its orders. The question then becomes, what's the appropriate remedial action in this case? The state has requested the maximum financial penalty under the contempt statute, which is $2,000 per day. The purpose of issuing such remedial sanctions in order to enforce a prior order through contempt is to try to get people to comply with that order. It is not to punish people necessarily. We simply want compliance with a court order. And when there's been willful disobedience with that court order, we try to find a remedy that's going to allow that to change. I do believe that $2,000 per day since the issuance of the order moving forward until there is compliance is appropriate. Looking at the totality of the circumstances, including but not limited to the financial fines and penalties already levied against this establishment by the Department of Labor and Industries, that has been insufficient for the Farm Boy Drive-In to comply with the legal directives issued by the state. Again, however, the purpose here is not to punish or to unduly harm individuals. The purpose here is to make sure that Farm Boy complies with the law. And thus, if Farm Boy or a representative on Farm Boy's behalf is able to provide proof that they have come into compliance with the law regarding these COVID restrictions, they may purge these sanctions and nothing will be owing as a result of this contempt. However, unless and until that happens, those sanctions will continue to accrue. I have before me here today the proposed order of contempt that has been submitted by the state in this case. I have added in on the filings considered by the court opposing declarations filed December 28th, 2020, because that's the only additional materials that were filed. I will note specifically that no legal filings concerning any legal standards were filed, nor were any legal arguments advanced by defendants' counsel in this case. There was simply the factual dispute about whether or not indoor dining is currently happening at Farm Boy. I will make it very clear, defendant's attorney's sole argument against these contempt sanctions on behalf of his client was that there is not sufficient evidence that there is currently indoor dining occurring at Farm Boy, and I have found that there is. And as a result of that, the law dictates that I find that there is contempt, and I do what is necessary to try to bring compliance with the court's order. Thus, I am now signing this order with that additional reference to the opposing declarations filed December 28th, 2020. Do either attorney have any questions?
Not from the department, Your Honor.
No, Your Honor.
Thank you. I have now signed this. I'm going to hand it to Madam Clerk. We have a hearing in this case set for next week. And so I look forward to seeing what legal arguments and filings occur in the meantime. That's going to conclude this hearing. Court is in recess.
All rise.
Yeah, I go.